So, all right. Again, got four here. What? Hi everyone, welcome to the planning board meeting on Monday, February 9th. We're starting here at 6 o'clock. We have one member, Jen Turcott, on Zoom. We're going to have somebody go ahead and share some information regarding our hybrid situation. Would you like to read that? Wait.
Yes. Pursuant to Chapter 2 of the Acts of 2023 and as amended as of March 28, 2025, this meeting will be conducted in person and as courtesy by remote means in accordance with applicable law. Question and point of order. Can the people on Zoom hear me?
Yes.
Okay, good. Thank you. Please note that while an option for remote attendance and/or participation is being provided as a courtesy to the public and board members, the meeting or hearing will not be suspended or terminated if technological problems interrupt the virtual broadcast unless required by law.
All right, thank you. All right, first up on our agenda is agenda item number 1 is administrative items. The first is minutes from January 12th and 26th. Has everybody on the board had a chance to look at them? Do you have any questions, any edits? Do I have a motion to approve them both at the same time?
So moved.
Second?
Second.
Any discussion on that? Okay, we'll go ahead and call for a roll call vote to approve the minutes of January 12th and 26th, starting with Jen.
Jen Turcott, aye.
We'll go to Tag.
Tag Roy.
Kristen Rappi. Brian Ferrari, aye.
You get a
Great, thank you. All right, next up is planning board administrative. All right, hey, you're good, you started. All right, thank you for coming. Just approve the minutes from January. Next up is TV administrative. Does anybody have anything that they would like to discuss? Do it down here. Jen, anything for the planning board administrative?
I do not.
Emily or Matthew? It occurred to me that we could probably give a brief update on the recodification bylaw, but we don't have it on the agenda. So, Emily, would you mind adding that for next time? That'd be great. Thank you. And maybe until we go to town meeting, why don't we keep both the recodification and the best on the that'd be great. All right, so first up, we'd like to go ahead and continue the public hearing for 161 Winter Street. This is for an EU administrative site plan review. We had a couple questions at our last meeting, so we'll give the applicant some time to present and answer those questions for us. Probably best if you come here to the microphone if you don't mind.
Sounds good. Do you want me to bring up my poster here?
Sure.
You guys have it on there?
Which is easier for you, Emily?
Probably the poster.
Okay, that's fine.
Alright.
You can just put it right here if you want. Wait, you won't be able to see it.
I haven't.
Yeah, okay.
Right here.
Oh, okay.
That way, kind of, but there's no perfect spot for that, it's not blocking anybody, it's just what it was.
Yeah.
Thank you.
Hi, I'm Max Fuller, Creative Consulting, here back representing our client Buildex for 161 Winter Street's ADU. As discussed in the last meeting, there was a couple comments where you guys would like to see the square footage labeled on the plan and a little bit more of the aerial extended out past the locus. So what we did was we added it on the plan, as you can see here, gross floor area of 891, and you can see a third page was added for a vicinity plan here, where we zoomed out a little bit more, so you can see a little bit more of the surrounding area. I would like to open up to any questions once you guys take a look at that.
Anybody on the board have any questions right now? thank you for doing that, for adding that to our message. That's helpful too. I believe, do you want to talk about the drawings, or would you like Bill Dex to talk about that?
Bill Dex.
Okay, all right, let's just stick with you for a second.
Okay.
Hold on. We have, I think the board wanted to, actually, no, we'll wait till we get to that part. Any questions for, Max? Okay. All right, so we'll go to that Bill Dex then.
Thank you.
For now, thanks. We might call you back, but already not.
Sounds good. I'll sit over.
Okay.
Good evening, Buzz Artiano, Bill Dex. How are you?
Good, how are you doing?
Good, thanks. So, per your request, no modifications have been done to the plans. We did file for a building permit with the building department. We had a discussion with him. I guess if you turn to page A2, there was some concern about the stairway counting towards the gross floor area. And I'm not going to speak for the building inspector, but he reached out to the state for clarification, which he has not received back yet. I guess I thought he was coming tonight, but
Yes, right to your left.
Oh, yeah. Sorry, I didn't know you were under that.
That's okay.
Oh,
Hi, Jim. Wozlowski, nice to meet you.
So, that's what I know. Our interpretation, if you look at your bylaw on page 55, it talks about accessory dwelling units. And then where it refers to gross floor area, which is on page 56, it clearly says, but excluding crawl spaces, garage parking areas, attics, and enclosed porches and similar spaces. Our opinion is this stairway falls under enclosed porches and similar spaces and does not count towards the gross floor area.
Perfect, thank you. Then Jim, would you mind popping up or just
Sure.
talk a little about this? And this is one of the reasons we asked Jim to come tonight, because this is new for us, and going forward, we're going to have more, so it's great that you reached out to the state for clarification. So tell us what you know.
Okay, so my name is Jim Wozlowski, I'm a building commissioner and director of municipal services in town. So I was talking with Matthew Hines, and this is a process thing that I think needs to be sorted out and clarified. And I had suggested to Matthew and to the board, to present it to the board that these applications should really come to us first to make the determination on the sizing of this before it even gets to you guys.
Okay.
And the reason being is that I know the applicant just spoke that they do not include that in the area, and that is not correct. The stairway is included, it's an egress path to get to this building, and it is included as an interior space. There's some confusion around determining what interior space is. People think that it's conditioned or unconditioned, and the act itself, the law and the guidance does not say that. So I reached out for clarification about similar spaces, and I don't hear back from the state, but I did a big analysis and I wrote this whole page up, which I don't have it with me, which I am going to forward to the applicant for them to take a look at and review. And we'll see where it goes from there. But as far as egress goes, I have another one of these sitting in front of me that you guys already approved, and that one's 75 square feet over.
Okay.
I spoke with council about this, and basically, council agrees with me that garages and closed porches are excluded. It's very clear in that. Similar spaces are not defined, which is the gray area. An egress path to get to that building is part of that interior space. The other one that was approved with the board recently had an entrance that entered both the garage and the stairway, and a little mudroom, and a closet, and a stairway, and they think that's a similar space. But it is not. It's part of that unit. The unit wouldn't be allowed to be built without getting to it and an egress path. So I've heard various things that other towns are doing X, Y, and Z. I don't really know, and I don't really care that much. I know that I was involved a lot with the state in a lot of meetings with lawyers and other commissioners when we were trying to understand how to determine some of this language. Because, it's typical of the state to put out something and then we got to figure out how to do that. So I was involved with a lot of meetings on how to clarify these spaces, because we knew we'd be standing here on this.
Okay.
So I spoke to council about this and some other matters similar to this today. And basically, if it doesn't meet the definition of, in this case, 900 square feet, so max based on the existing structure, then it doesn't fall under a protective right use ADU. And that determination is up to me, which I haven't had anyone appeal that yet because these are kind of new. I asked if there was any litigation yet or anything about interior spaces or what similar spaces mean, and there has been none to date to clarify that. As a matter of fact, it's been pretty quiet on that determination. So that's kind of where we stand with that. So I just suggested to Matt that I think as a process to help that we take in the application, we determine the size and everything, and then we'll refer to the planning board. It seems to make more sense to me and for the applicant.
That makes sense to me. Certainly, we can certainly talk about that. Question for you, Jim. So if it comes, and so is that something that you would want to, if you would want to see that clarified in the ADU bylaw? Would that help?
Yeah, good luck getting that from the state. Oh, would I like to see that clarified in the bylaw?
Or is it something we can do process? I'm just trying to figure out.
Well, that's a really good question because
I think it's probably a process.
when you say would like that clarified in the bylaw, you're talking about the term similar spaces.
Well, maybe that would be one thing. Certainly, I was just going to get to that. I was thinking more along the lines of, do we need to spell it out in the bylaw that the first step is it goes to the building department and they approve the square footage, and then it goes to the planning board. So I
It
think
wouldn't be a bad idea. It could be a change to just clarify that, or, you know, like everything that we do, we don't have. There's so many cases that are popping in my mind that aren't clarified that I need to explain. So it would be helpful for an applicant.
And then the second thing I was thinking is, would it be helpful once you get some clarification from the state to include it, because then it would save our applicants time, would save your time.
Absolutely. Yeah, I mean, the biggest challenge I have is trying to manage the expectations of everyone here and trying to streamline that. A lot of times I become the doorstop of it, and I have to make the determination with what I know about it. So, yeah, it's tricky because I've heard things like some towns aren't including unconditioned spaces. That isn't what it says. The act is kind of clear on that. So, yeah, it's tricky. We had someone that built one of these, tried to get ahead of the ADU before we adopted the bylaw, and they had a basement ceiling of 7 foot, which made it an 1,800 square foot by definition. So they had to build a whole system in there to make that ceiling height 6'7". So for basements, it's 6'8". It gets kind of complicated. I had another case in front of me, and just to let you know why we have to go through this determination, I got someone in front of me that this one that's 975 square feet. They wanted to see my math, how I figured it. I quoted it to them. The architect came back with his interpretation that slope ceilings are areas that are below code. But he's wrong in that because code allows up to 50% slope areas in rooms. So it is, in fact, interior space. So we get into this minute minutia that's not defined, but I have to apply the code and what the standard is. So.
So if we want to, the whole goal behind the document bylaws is to simplify it for our applicants, our residents, and for our employees. So,
Right.
I sounds like those two things. Unfortunately, we don't have those in place yet. And most
That's
will
right.
come in place for this town meeting, but that might be something we could look at for the.
I did a nice analogy that I'm happy to forward to the board. I think I gave a copy to Matthew on that similar space issue, which I am going to forward that to the applicant, and all these applicants, so they can understand that.
Oh, okay.
Yeah, I think that's the board back and started talking. Go ahead and please.
If you want to go.
No, good.
Well, I just was going to suggest that rather than going right to suggesting amendments of the bylaw, this might fall into regulation, which we do not have to go through town meeting. It's my understanding, because the bylaw sets the frame. I mean, we're just filling in inside the frame with detail. That's a regulatory matter, and if, as you say, there are different cases and the state's involved, and this is evolving over the next year or 2 years, and we pass a regulation and the state contradicts it, we simply change the regulation. We don't have to tie the town up with that kind of minutia. That's what I'm, is that correct, man?
Yeah, I think this can be more of a procedural thing. I mean, ultimately, I'm not sure if we could legally mandate they apply for the building permit anyway, but I think in practice, we can certainly tell every applicant or potential applicant, we can recommend to them, especially if they're getting close to 900 square feet, we can say, we strongly urge you to apply for the building permit about a month, maybe a month before you apply for the site plan approval to us, and explain the reasons why that's the case. I mean, I think if it seems like most of what we're getting so far is right up to that 900 square foot borderline where it's difficult, but we're going to get a few that might only be like 400 or 600 square feet. So for those ones, there's probably no need that one. Yeah, like if it really is clear they're below 900, then maybe there's no need to do that.
I'm gonna just jump in there for a second, Matt, because Matt brings up another point that is really important, is that we need substantial evidence to determine what the existing structure is for interior space. And we receive napkin sketches sometimes, like, hey, this is it. No, that we need an actual floor plan that we can verify these spaces, and we also need elevations to understand what the ceiling heights are. Because basements can work for somebody that has a small 900 square foot ranch house, for example, and has a 900 square foot basement with a 6'8" ceiling height. Now they could build a 900 square foot. But if they had a 6'7" basement, then we couldn't use that basement square footage to determine the area of the existing structure. So then it'd only be limited to 450. So this is why it's kind of important that they come and apply. And I don't know if we really need to create a regulation or bylaw around that, because very simply, when someone comes to us with an application, I'm just going to give you an example. If there's any conservation issue involved, I have a conversation with them and give them a general idea of what has to happen, but I say, you need to get through door one before you even apply for us. So I think it's just a procedural thing for us to just say, hey, someone goes to his counter, if you really need to apply for a building permit and get this thing sized appropriately before you can apply.
So maybe the process isn't something we actually have to codify.
Right.
But the language about the square footage, though, I would think that.
That's in the pack. It's in our bylaw, which is copied verbatim from the guidelines set forth by some large acronym.
Yeah, I think if you yeah, sorry. I mean, I think if we tried to put all that details about how to calculate square footage on our zoning bylaws, it would be too much detail, and it might, as Ted mentioned, that might evolve over the years anyway, over the months, and that's better suited to be kind of within the authority of decision making of the building commissioner, which is Jim, obviously, just because it's such a complicated thing. We don't necessarily want to try to we're just not qualified to try to wade into that too deeply. Like it can get. You're talking about, just from what he said earlier, like with the slopes, slopes of, the claims about slopes and someone can see that happening. He's the only person, really, him and policy over the people probably qualified to make the determination. And I mean, even if it's clearly below 900 square feet, there could always be an issue with like fire code and exits or all kinds of things where it makes sense, perhaps, for them to submit the building code application to Jim either first or simultaneously, so that if it turns out there is a crucial problem, he can alert the applicant before they get too deep with the planning board, where maybe they've already gotten approval by the planning board, and they're going to go all the way back to square when they get potentially.
And I don't know the timing once they apply to the planning board to get on the meeting, but for building code purposes, we have 30 days to respond legally. And that clock restarts every time we communicate we need something else, because it's considered an incomplete application at that point.
Anyone else report that? Jen, is there anything no question?
Good, thanks.
Thank you. Is there, okay, so I hear both sides, yes, would help, no, but maybe we leave it for now, you tell us, okay.
I think it just is a process.
Okay.
We have a lot of processes that happen in town that we just inform them when they come in. So,
All right,
well, we keep it simple.
Okay.
Why reinvent that wheel?
well, just let us know how we can support you.
Okay, thank you.
I think at a minimum, I'd like to have clarity and transparency for the homeowners, because in this instance, Doug's already submitted twice,
Right.
and now
Yeah.
we're finding we have to do this again. And don't like us doing this, so there ought to be a way, an advisory, a bulleted list, where we stand on this. I don't know what is that.
We have one drafted up, just to let you know.
Yeah,
We have to be careful about drafting that up, and we have a disclaimer at the bottom that this is a general bulletin.
right, general.
All right.
All
You
right.
know,
We've got it.
refer to 760 CMR for the actual 71 languages.
Use the right hand, left hand, know what we're
Right,
doing, and
right.
advice to give people. And,
Right, I agree. I do think we do want to keep it simple for our residents.
Yeah, we on our second round draft of that. We drafted one up for that reason, so we can hand it to people. I spent a lot of time explaining this and trying to streamline it for everybody. These two just got ahead of us before they got to the board first, before we got a chance to look at them, so.
I'm sure that we look at this and thought that they look fine.
Right. It's that gray area, unfortunately.
Okay.
We'll get through it.
All right, yeah, they can let us know what we can do.
Okay.
Thank you. And as far as this particular applicant, then is the guidance to wait for them to hear from you before we approve?
yeah, I mean, as I see it, there's 100 and something, 102, 110 square feet in the stairwell. And you're at 70 right now?
Yeah,
So you're gonna have to shave out
we're gonna have to shrink it
20
down.
feet,
Yeah.
80 feet out of the square footage.
Right. And if that is something that you guys need to see, or make a decision, I suspect that is important. Yeah, it's sitting on my desk right now, so, I'm getting to just get some of the minutes.
Any questions, Rob?
I do tons. Thank you for that explanation. So it sounds like the site plan part is resolved, we're just waiting for the square footage issue? Everyone's satisfied with the site plan and location, et cetera?
I apologize if this has been covered, but I know that it sounds very sensitive to fire truck access. I personally have a long driveway, which is a big challenge. Do we know that that turn area in the back is suitable for turning around the fire engine?
I don't think we have this fire truck.
I don't know if it's codified or not. I'm just asking the question. If the fire department knows about this,
George sends it,
Yeah, it's gonna happen.
and they said they had no issues.
Okay, good. That's what I thought. Thank you for confirming that. Yeah, okay.
I mean, I guess as far as back to what the issue of the site plan, it seems like we've pretty much gotten the answer from Jim that at least as it's currently submitted, the floor plan is above 900 square feet. So I assume that'll need to be adjusted by the applicant. And so, if that, I guess the question is more for the applicant, if those changes, affect in any way the site plan in terms of like the building footprint or maybe the size of the building envelope or how the building, where the doors are located, like anything relating to the larger site plan beyond the building envelope, then I would assume we'd want to make that continue the public hearing to give time for that to happen because we can't approve an application including a site plan and then it turns out that it's changed anyway and you have to go back and reapply. As far as just the floor plans themselves, if it's just a question of rearranging floor plans and the footprint and all the exterior stuff doesn't change, then I guess it's up to the board, does the board feel as though they want the floor plan to be totally finalized before they approve it? I mean, in practice, that may be difficult because sometimes, later in the process of those floor plans, you get tweaked a little bit as it's twice before that, maybe a closet gets moved to that. So I would think the board maybe doesn't want to get into too much detail with that. I mean, typically what the planning board does for site plans and all kinds of applications, the planning board deals with, site plans and setbacks and where building footprints are and building heights and uses, of course, and so forth. But usually planning boards don't get too deeply involved with actual floor plans or what happens kind of within buildings, how floor plans are laid out. That's typically more within building inspectors and fire code and all those kind of issues. But that's up to the board.
Reminds me of what the planning board does when we have the ZBA application and you guys defer to the ZBA.
Right.
I think how we should probably handle this process-wise is when we review it, we could send a memo to the planning board, to Matthew, that you know, I've reviewed it, and this department's reviewed it in its compliance with X amount of square feet, just so you have a clear understanding of that.
You know, I think that, yeah, I think so. You're saying it's like doing it almost in the opposite order.
Yeah, I mean, we really have to size it right. You guys could approve something and come to me, like this case, and, you know, we go disagree. Now, these guys do have a right to appeal my decision, which no one's done that yet, so, I'm wide open. I don't get offended by that if I'm wrong, but I've done a lot of research about it, so basically that goes. But I think that we should be reviewing these first. I guess we can certainly forward a memo off and, you know, we reviewed this for this compliance with the bylaw regards to size, but however the language we need to put in. Just to make it clear.
Yeah, I think that's probably a good thing to have.
I don't think our jurisdiction has anything to do with the board.
So I think if it keeps maybe going forward, it goes to your department, and you can say, yes, square footage is great, and we can review this site plan. So because we've done it backwards this time, do we want to continue the public hearing until that's resolved? Or, I mean, alternatively, we could say it's good, but
Can I weigh in on it?
yes, sure.
The applicant, the owners are actually on Zoom, and it's Beth McCarthy. I do need to confer with them, but I would appreciate it because we've been hearing open.
Okay.
While we're working through this, I was just looking for a consensus on the general site plan, you know, to see if there's any outstanding issues. I look forward to, again, this is not adversarial. I don't want you to take it that way. I look forward to the letter from the building inspector. I need to confer with the, you know, the client to see if they would like to appeal. I am definitely would like to appeal because I want this in writing definitively, one way or the other, from the state, because we are being allowed to do this in many other towns. So I think it'd be helpful for everyone to just say, these are the rules, this is the way the state's interpreting it. And again, it's not adversarial. I don't want you to take it that way.
So I think we're in agreement. We'd like to invite it to everybody. As I said, we want to make it fair for everybody. We want to make it fair for the applicants, for residents, and we wanted to provide our building inspector and us as well some very clear guidelines.
Yeah, and getting back to the process, I agree. A lot of towns, we do a zone permit first, application first, that resolves the square footage, you know, the gross floor area question. And we do provide accurate floor plans on all our applications. I know some people aren't doing that, but we do that.
Absolutely, nice job. Appreciate
Yeah.
that.
And so again, we want to be compliant 100%. There is, you know, we have a philosophical difference between what's gross floor area and what isn't. And it'd be good to get that resolved. So we do have several other bills coming up in Duxbury. So, and this question has already been asked. So, it'd be, you know, we want to work together and make a smooth process and get it done. So I appreciate everyone's time tonight, and I look forward to the letter from the building inspector, and then I'll confer with the clients, and we'll go from there.
All right, that sounds great.
Thank you, everyone.
I appreciate it. So do we have a motion to continue the have a roll call vote to continue the hearing for the ADU, for the 121 Main Street ADU administrative site plan review, starting with Jen.
Until
Oh, hold on a second, Jen. So what do we want to continue to?
I would say, give it,
Do you want 2 meetings?
yeah, if you could, yeah.
March 9th.
Then a couple days after that, so like that Friday, because file.
So, sorry,
Oh,
one of the
there
pesky deadlines, yeah, the deadline for the time I think is something like March 4th. I got it, I wrote it down. It's over 40 words. So I guess I'd suggest February 23rd.
Yeah, and again, if you need, we can, you know, just open and continue it, that's fine, so you know, the decision from the state. So,
I think we might have
I
a,
think we'll probably have a decision by February 23rd. Well, I can't speak for Jim, but I think we'll.
Yeah, it depends, like if they, you know, if they decide to appeal the decision, they usually see those within 30 days, so I don't, you know, the state, and I don't know anyone that's actually appealed one of these to the state yet, so I'm kind of curious to see what happens with that.
But we'll need your official letter, right, or your official determination.
Yeah, oh, I'll have that done, yeah. I'll have that done before the end of the week.
Yeah.
Hopefully tomorrow is my plan,
So at February 23rd, we'll definitely have that.
Yeah.
And you'll have had plenty of time to mull
yeah,
it over.
and again, I'd like to just be on the next agenda, and if we need to, you know,
Okay.
take it, it's fine.
yeah, and if we need to, I think if we need to extend it, I think we also have to extend the 40 working days, such extension. that.
Yeah, that's fine. Whatever you need signed for ourselves and the client, absolutely, we'll get you that.
So do we need, Emily, do we need a couple working days after the next meeting? Or do we just approve it and off it goes, or do we need, is the staff, do you need to do anything? I don't know, what was the question? Yeah, sorry.
Oh, I'm sorry, I mean, I think that normally we, just to be on the safe side, we need about a week, but if we continue this here to February 23rd, I think we're in good shape, because the decision deadline, I think it's like March 4th or March 5th. Yeah, March 5th, so that gives us like about 8 or 9 days or so.
Yeah, and again,
I think we're probably on
yeah, we're fine signing an extension if it's needed.
Okay.
Yeah, I'm not gonna play that game.
Okay, all right, so we'll try that again. So, can we still use the motion that, okay, all
Just
right.
set it the date of March, February.
Okay, so we're going to add to the motion that we will extend the open hearing to February 23rd. Hearing the discussion, we'll call.
Well, we're continuing the public hearing. February 23rd. You said extending it.
Oh, sorry, continuing the public hearing to February 23rd. And no discussion amongst board members, so we'll call for a roll call vote, starting with Jen.
Jen Turcotte, aye.
Matthew Ray, aye. Sarah Carpenter, aye.
Susan Rath, aye. Lauren Curry, aye.
Pete Ganda.
And motion passed.
All right, thank you. Have a great night.
Okay.
Yeah, no problem.
All right, thank you. Jim, appreciate it. Have a good night. All right, next up is, all right, so next on our agenda is continued public hearing for 51 Wadsworth Road subdivision. The applicant has asked for an extension. Since it's still open, or continued, we can't have any discussion other than to agree to discuss whether or not we want to extend the hearing. So do we need to have a vote on that then? Is my message?
Yeah, I guess just a vote to, first a vote to agree to extend the deadline to March 20th. The applicant's already signed the form to agreeing to extend the decision deadline to March 20th. And then just a vote, if the board is willing to continue the hearing, just a vote to continue the public hearing to February 23rd, which is what the applicant requested. And that just gives the applicant more time to do the drawings and stuff, which is what they requested.
Okay, so, we'll, need a motion to extend the deadline to March 20th and then continue the hearing until, the next couple days. Do I have a motion? I'll entertain a motion.
So moved.
Second. Any discussion on this?
So to be clear, what we're doing is we're combining the two to extend the deadline and then to keep the hearing open until February 23rd. That's the combined motion. Okay.
All right, any discussion? I will call for roll call vote, starting with Jen.
Jen Turcotte, aye.
Matthew Ray, aye. Sarah Carpenter, aye.
Rafa, aye. I'm sorry, aye.
Pete Ganda.
Okay, motion passes. Thank you. All right, next up is our last item, is our public hearing for the annual town meeting, 2026 zoning article for the proposed battery energy storage system, otherwise known as BESS zoning bylaw. Do we need a motion to open the meeting, public hearing?
Sure, I guess.
Just do it.
Some people just announced their
All right, we're gonna open it. We're gonna open it. All right.
Sorry, Kristen, actually, I just wanted, before I forget, just to sign this and date for that extension agreement. Thanks.
Okay. So this hearing is, for a proposed zoning bylaw amendment for battery energy storage systems. This will govern the location, construction, and operation of battery energy systems in Duxbury. Why do we need this? The Commonwealth passed the Clean Energy Bill in November 2024 that streamlines the permitting of battery energy storage systems in Massachusetts. The town would like the opportunity to regulate how and where these storage sites are located in the town. This is also to We have had one project that was proposed in town, and we didn't really have we didn't have a byline to help us figure out how to do that. That's probably why we're meeting today, why we were proposing this bylaw, sorry. So what we'll do is, since we don't really have a proponent per se of this, we do have somebody from the Alternative Energy Commission. And you, right? Did you want to speak tonight, Wendell? Yeah, okay. So what we like to do, we've invited Wendell to come and talk to us a little bit about the code of having that in town to really better understand it and going deeper into about the more details. That sounds good. Okay. All right, Wendell.
Good evening, Wendell Cerny, Bayers Lane. I'm the chair of the Alternative Energy Committee, but just a disclaimer, this does not represent a policy statement from the AEC itself. I'm just here as somebody who has investigated it. We've discussed it within the committee. In fact, that company that had that proposed at West Street came to us for advice, and at which time we told them, well, in theory, we do believe that the DESSs are necessary if you're going to be relying upon renewable energy, because the production of renewable energy is intermittent. You have to have ways to store it, and there are other reasons to have battery storage. So we did tell them that there are many other things that had to be considered at the same time. That is proximity to neighbors, safety, etc. So that was as close as we came to a policy statement, given them some advice. So, and looking at the bylaw, this is just, the first thing is, what are we talking about here when we talk about a battery energy storage system? What capacity are we talking about? Because when I look at it, it said, okay, what if somebody wants to have put in a battery wall in their home or an adjacent structure on their property? Does that have to go through this whole procedure? What if there was a neighborhood that decided they wanted to do a microgrid, or even within the town itself saying, you know, we have the center here, we have the police department, the fire department. You know, if we could do solar production and have battery storage as backup, so then this building, for example, in case of a power outage, this would be a safe place to come. So that's the first question is, what are we talking about here? Because there are different levels. So for a home, for example, you might have a battery wall that was around between 10 to 40 kilowatt hours capacity, that's it. For a microgrid, it's like 50 to 215. But for a whole town, now we're talking about megawatts, 15 to 20. So that's a question I put to you to say. But
I think I can.
where does this regulate?
I think I can sort of answer that to some extent. So the bylaw specifies that the threshold is 100 kilowatt hours, and as you say, typically for a home, it would typically like maybe 20 to 40 at most. I don't know about microgrid, but for a home or small business, it's probably going to be less than 50. So basically, for anybody who just wants like a battery backup for their own home, like maybe linked to a solar thing, or just to be ready for power outages, those are typically maybe from between 10 and 40. And so those would not be regulated by this. And I believe at the moment, from my discussions with the building department, they get some of those applications, on a pretty regular basis, usually tied to solar panels on the roof. And so people just go through the building permit process. It doesn't have to go through the planning board because it's not a big deal. It's just like, whatever the size of a suitcase or whatever, it's something that goes, in the basement or the backyard or whatever. And those are fine. Obviously, it would be kind of absurd to expect them to submit applications to the planning board every time they do that. So the threshold is 100 megawatt hours. So, anybody who's trying to do like a commercial project where they're actually making a business out of it to kind of, put it on its own property and sell it back to the grid as kind of a business proposition, as opposed to just trying to back up their own house or small business. That's probably gonna be like, typically at least 1 megawatt hour, which is like 1,000 kilowatt hours or more. Sometimes there's 10 or 20, 30, 40, 50, whatever. So those are, dramatically bigger. And of course, those are the kind of thing we're trying to regulate by this bylaw. So I think that obviously we just got the threshold from the template that we had before, but it seems like 100 kilowatt hours is actually a pretty good kind of dividing line between the little ones that can just go through voting for a process and the big ones where it's a real project that is on the property and we wanted to go through this zoning bylaw through kind of a site plan, especially for approval type process through the planning board.
So I'm sorry, but I just need to have repeated what would be that capacity? Because I think I just heard two things. I think I heard megawatt hours and kilowatt hours. It's 100?
It's 100 kilowatt hours is the threshold, is the kind of dividing line. So below that, a proponent, a person doesn't have to go through this whole zoning bylaw process because it's too small for us to kind of worry about. It's usually just be a backup for a house. Anything above 100 kilowatt hours, they do have to go through this full application process as specified in this.
Okay, so that, for example, there are some 70 plus projects of BESS being around the state right now. And there are three in Plymouth, and so they're operating beyond that, with that threshold for certain. Okay, so now they are there, and I would say in those communities they have judged that the benefit of having these BESSs, it outweighs some of the safety concerns. So that's all taken into consideration. So, and again, there's 70 projects in the state. Provincetown has a Eversource just installed this. So Provincetown has a 38 megawatt BESS right on their transfer station property. And so that's designed so that in case there's a power outage, that facility can provide power to 11,000 homes from Provincetown to Wellfleet. So I guess what I'm trying to say, or trying to get point across here, is that whatever happens with bylaws, does that necessarily mean that we say that this is not a safe technology? And therefore we want to put up barriers. See, that's what I really would like to get at. It seems, if I even read the preliminaries, that seems to be something that has somewhat been decided that they are not safe, and we're going to put up, barriers to make sure that these things are not built here. That's my interpretation. So that could be accurate or not. What would you say?
Great question. One of the things that we talked about in our last meeting was the fact that really, and I say battery, what we understand, or what I understand, is that battery energy system would make more sense in an industrial, part of town. And unfortunately, Duxbury doesn't have that. And so, as a result, we're trying to figure out, well, what's it about? How do we comply? How do we allow these? And how do we also ensure the safety of residents or of our residents? So it's definitely, I wouldn't say we're not disallowing it, and we're not, we are definitely put in some constraints because we're primarily residential. Does that make sense, Mama?
Yes. So then my follow-up question is something I mentioned just, earlier. So would that mean that, for example, people on my street get together and say, you know what, you have solar panels, we can share in that production, and we'll site a battery storage system on somebody's property. Would that be disallowed? Because now we're moving up into like 215 kilowatt hours possibly. You know what I'm saying?
Yeah, I think I think potentially it could, if it's in the wrong location, then I think potentially it could be still have.
Yeah, because when I look at, you're wanting like 100-yard or 100-foot setback on all sides, for example, and then that might be tough. It might be tough. I'm not saying these things are happening. For example, take Fieldstone Farm and say, hey, geez, would be nice for putting this in now. Why don't we just put in a battery storage unit, make these people close to off the grid in a power outage or something, or just to, a way to save energy or to maximize solar production. So I guess that's my concern. And as far as the safety goes, I guess I got to go back to that. It's like, okay, do we accept risks in our infrastructure now as it stands? So, for example, for the delivery of natural gas, having transformer substations, are those risks that we already take? And so, yes, we do. And I mentioned this last time at a meeting, and I talked about we drive around unless you have electric cars. Well, then we drive around with gasoline fuel, and it's an explosive fluid we're driving around. So I'm just keeping what are the risks that we're willing to accept, recognizing that the way that we've used energy in the past, and it's just not, it's having an impact on our planet, So I guess that's the big question.
That's a good question.
Yeah.
I'm not sure that we have an answer for that one.
Yeah. So because if this goes through and we get the specifications to delineate the wordage of this bylaw, then that would make it very difficult for these other things to happen, which might be sensitive. That's all I have to say. So.
Thank you. Thank you. I appreciate you coming tonight and talking with us about it.
That's okay. And just a comment. The amount of work that's been put into this and everything that you do, I think that everyone should really appreciate that, because it's long hours, a lot of thought, and thank you.
Wendell, before you go, you've raised a really good point, and I think it's worth elaborating, which is that, and in your communication with the board, I really appreciate that we should be making decisions based on solid data and not fear or reaction to some unknown we don't understand. My main concern is noise. The safety, though, I would like to speak to and ask if because these systems always run in generations, right? First generation systems use lithium-ion batteries, just like in the cars and the batteries and notebooks, And I think we're into the second generation, and there's a third coming up. Do you know what the mechanics of this market are? Because you have.
Well, I'm not an electrical engineer. I have studied these various iterations in the systems, etc. So we're advanced enough to say, look, there are projects going on in town, in towns in the Commonwealth. The state has an initiative to try to increase this. And say, okay, why would they be doing that if they realize that there was this major safety hazard that we're not there now as far as safety goes? Mm-hmm. And then I occasionally will go up and see this International Space Station going by, and I said, what's going on up there for storage? Well, there they are. They have lives of all these astronauts, and they're using battery storage. I said, oh, okay. I don't know. And then from this common sense point of view, I would say, okay, I'm interested in putting in these systems. I'm a company that does that. So am I going to now risk putting that in and then knowing that I'm going to be sued? So in other words, if there's faith in this technology, enough so that the state until recently, the federal government, was in support of this. So that leads me to think, okay, these are safe. Not that there are some things that have to be done to make them perfectly safe, but they're safe. Yeah. So,
Yeah, that's what I was just looking for, actually,
Yeah.
if we could write some report or something about the
yeah.
state of the industry, that might.
But I don't know, but you tell me, I mean, this is gonna be going before the, town meeting. Would it be helpful, to speak at that time and actually have some statistics? I don't know. Or is that too much?
I think it's vital data, that's what you mentioned. I'm trying to reverse your point, that we should have hard data about this,
Yeah.
know what we're doing.
Would it be reasonable, would we feel comfortable having a proponent of this? For 5 minutes of presentation? Do we have any, we should have a presentation. Planning board, we don't really want that much. I think
That's
it would,
ourselves, really, people would have to do it,
yeah,
right?
right. I would think it would be helpful.
Okay, so are you saying at the town meeting or there's another meeting before, or at town meeting? At town meeting, you'd like us to do
I
that?
don't know, I mean, we've actually got town council here, so we can ask her, but I think you typically, it'd be more appropriate maybe for the planning board to be the ones giving the presentation. I mean, town council can correct me, but I mean, also don't forget, like, once it's kind of open, once it's open to comments from the public, the different people who talk and sort of how thoroughly they can articulate things within the short time they've got can make a really big difference. And so if somebody, like Wendell or whoever, gets up and speaks thoughtfully and kind of passionately about it, that can make a big difference in people's minds, at least in my experience. And so that's another thing we should have to be aware of.
It would be great if you were planning to speak and maybe come up with 5 to 10 bullet points, like, and just to educate people.
And AEC will be having a table at
Yeah.
town meeting, and I think it would be a good idea if we have a fact sheet.
Yeah.
And that people can also. And so, by the way, I think I've been speaking at around 50, maybe 60 decibels, which is another.
You did 70 there for a moment.
50, that's 50 decibels, I don't know, that's gonna be, leaf rustling is like 30 decibels, so I don't know. The decibel thing, I'm not too sure.
What's the leak?
About 30 decibels.
Leaves
Rustling, not like, I'm sorry, rustling leaves.
The wind.
What's the leaf blower, do you know?
Oh, leaf, 115. A motorcycle was about 100 decibels, which is all part, ambient road noise. So there it is.
Part of it is smoke. Okay, Wendell, thank you so much.
Okay, no, thank you for giving me the
It'd be
opportunity.
great if you had a flyer, you could definitely plan
Okay.
to speak as an audience member.
Okay, so I'll be in touch and about presentation, I'll have to have a flyer. And I'll run it by you, say, what do you think is the answer? Okay, great.
All right, do we have any members from the audience who'd like to speak? Okay.
Hi, Kim McEntee from Rosewood Court. I just want to, if it's appropriate, to just say one thing about what you said about it's not so much that people reject the technology, because I think we don't reject the technology. I think we reject the kind of placement, and that it's not that it's not safe. It's maybe not safe 10 feet from somebody's existing primary residence. So I think that's kind of where, that's the sell, is that it's not the technology, it's where it's placed. And New Leaf, as well as many of the other energy companies, clearly state on their own website that the application is commercial or industrial. They don't talk about it in terms of residential. So I think that was the big deal when it showed up in everybody's backyard, and it was 40 feet from one of the neighbors and their 3 kids and their dog. So anyway, I think that's a welcome piece when we speak about the technology, because I think we all can learn more about that. I did have 2 questions about your final or semi-final version, and it was about the noise. The first one was about, I think it's 622 something, it's the F section. And I just wondered if there should be a noise expert included when first sound test happens pre-construction. It does appear that you leave that up to the applicant, and no offense, but the applicant probably, I think I would feel more comfortable, maybe other people would feel more comfortable if there was another professional there that was determining that first number, because that first number is where we begin. So whatever the ambient noise plus 10 or 50 or whatever that is, that's an important number. So I see that you have lots of technical expertise included later in the process, but that first number does appear to be a really important one. So that was my question, is that something that could be included? And my second question was about the 90 days. You say that post-construction, they would have 90 days on the applicant to step up and tell you whether or not they're meeting that sound. That's 3 months. I mean, you give the fire department and the police department 30 days to say if this whole project should work, but then you're giving something that's already in play 90 days to tell us whether or not they're meeting whatever the decibel. So I guess my question is that, should it be considered maybe a 60 or 30 day for them to say whether they're meeting their own sound criteria? So those are my
I want to thank you for coming tonight. You've been a huge proponent and you've been very helpful in providing us.
I just want to make it good for
I
everybody.
really appreciate that.
Yeah.
To your point, like it's again going back to the fact that you don't have an industrial area. We're
Right.
trying to
We're stuck.
right. We're trying to figure out the best way to allow this in town, but it's not up against your property.
Well, I don't think really anybody, if somebody wants to volunteer to have it in their backyard, then I think we would have a winning hand.
Right.
But I think most people would not volunteer to have that even 100 feet from their backyard. And the sound, the other thing you talk about is the potential of the buses will get louder. That is not a potential, that is an absolute. It's the insulation in given the elements and given the degradation over time, it's like your appliances in your kitchen. They get louder because that insulation dissipates. So they just do. So that's why we're trying to kind of box it and make it safe for everybody. That's it.
So I think you go back to your two questions. The
Sure,
first one
yeah.
under page 5, it's 622.6F.
Yeah.
It was basically, are you suggesting that a third party provides evaluation as opposed to a self-evaluation?
I just think it makes better sense that the applicant probably will demand to be there. I would if I were the applicant, but I'm saying that it makes sense to me to have a neutral third party also there, because they could say, well, ambient is 115. It's the motorcycle. And I'm not sure there would be, I just think you just want to make sure everybody's in agreement. That's your starting number. And that will, then we're all protecting that number as we go. So that seems just prevent, make it smoother to do that. And then the 90 days, I just thought that seemed a little long for them to figure out if they're actually doing it. Because if it's not accurate, 3 months is a long time for somebody to have to listen to the,
All right, thank you very much. Anyone else in the audience? Go ahead.
Go ahead.
Siobhan Pernick, Duxbury. I live in Hall's Corner. So when I first saw this, I just thought, I didn't know what was going on. It just blows my mind if we had such an uproar on having a fest out at West Street. And I'm not saying put it not in my neighborhood. It was a horrible idea to put it there. Now you want to propose the 3 biggest spots are Hall's Corner, St. George Street, and down by the bay, Sag Harbor. The problems and considerations that I don't think are being addressed. You're putting it at 1 our three biggest commercial areas in town. You're gonna put something like this, and I don't think the safety things have been addressed properly. Any of these areas, safety, near our water, near our wetlands, near business, which is right on top of residential, which is right on top of, in St. George, the schools. Every single one of these areas have traffic issues. We have a traffic study, Paul's Corner working group that can't figure out why we can't do away with parking spots that are in the roadway. And you're gonna add potentially, if this goes down, or if we have a problem in Paul's Corner, I'm gonna tell you, you're gonna lose lives, you're gonna lose commercial space, you're gonna lose homes. And I did a little bit more research and I talked to our representative, Ken Swayze. There are 3 bills currently up at the State House trying to establish stronger siting things, buffer zones, moratoriums on these. So I think Duxbury, by trying to push this bylaw through, is putting the cart before the horse. Let the state figure out where these things should be going. They don't have to go in every single town. This is Duxbury. We're so anti commercial business industry. And this is an industrial use. And you want to put these in 3 of our most prized, not that neighborhoods are not prized areas, but you take our bay down, the battery thing has an accident, a spill, noise. We got the oyster industry, we got the boating, we got people, we've got the maritime school. Maritime school, 500, 600 kids every day during the summer. What are you gonna do when you have to evacuate that? And I just think if the state, and Swayze's pretty adamant that these things are either going to be addressed, one of the 3 at least will pass. So why are we in such a rush to put this on board, our bylaws, if the state can't even decide where we should have these things and why we should have these things? I think we're just jumping the gun here, and I've heard, oh, well, there's really no spots in Hull's Corner or down by the Bay or St. George that anyone could buy. Well, I got a gym behind my house, and if that gym should hit financial hardship, who's to say someone doesn't come to her and offer her an offer she can't refuse? You put one in there, one, it's going to be awful close to my house, but you got a doctor's office, you got wetlands on the other side of that, traffic. They can't even get a fire truck into that gym area. That's probably the only spot in Paul's Corner. I don't know where you would put it down by the bay. I don't know where you would put it over at St. George Street without impacting school, traffic, wetlands. I just think the town is putting the cart before the horse. The state, 3 bills at the State House now, trying to push these off, or at least wait until we have a better idea of the impacts. And I think the 3 spots, the 3 main spots you've picked are just ludicrous, sorry. I mean, I know you've done a lot of work and research, but you've got residential right on top of business. You've got, on any given Saturday from Memorial Day till whenever the races stop, I can't even get out of my house. So what are you going to do when all the traffic is there? The kids are walking. You got cars in Hull's Corner right now with all the snow. Half the parking spots are gone. They can't get fire trucks into where the gym is. That building in Hull's Corner is not in any zoning compliance because it was so old and it was there before. I just wish you would do a little bit more research and wait to find out what the state is going to finally decide on building events like this before you put our town, which is no business, no industry, and you're putting in industrial use in three of our most important districts in town. Just felt like we needed to come and try to figure out maybe we should review this a little bit more. I'm not saying not my neighborhood. I don't want it in West Street. I don't want it anywhere in Duxbury. I think there's got to be, and I know you can't say, oh, just put it in Kingston or Plymouth. I'm not trying to do that, but maybe it shouldn't be in Kingston or Plymouth either. If we don't know, and it sounds like there's way too many questions on environmental impacts, safety impacts, traffic, location, environmental. So I just hope you would reconsider maybe postponing any final decision.
Well, thank you, Siobhan. Appreciate you coming tonight. So there are a couple of things just to elaborate for you. The state is, if we have a bylaw, we are required to have a place where we can do this. So we can't have 0%. And so even though you may not want it here, we are required to have it here. And so that's our challenge, is to find that spot. And one of the reasons we actually looked at the business districts is because we thought they might decide that they would like to have a shared solar energy space, or something like that. So that's one of the reasons we chose those. And as far as it being near your house, that this wouldn't be allowed within 200 feet of a residential area. So it won't be a church, it won't be at the gym next door to you.
Well, where are you going to put it in a house corner that's not within 200 feet of a house?
But I think it just answered your question.
Oh, we're about down by the bay, or at St. George Street. So, like, you are eliminating having this. So this is just semantics. If you're saying it can't be with 100, where are you going to put it down by the bay? Where are you going to put it at St. George Street that you're not within 100 feet of a house?
That's the point.
Have you seen the map yet?
Yeah, I have.
That's the point.
But
That's why that land is there, is because the setbacks are such that nobody can use it anyway. But we're complying with the state. It tells us we have to get it, but these guys were smart enough to limit it to 10% of the town. And some of the areas they selected, it's not going to work anyway because of the setbacks. So they're ahead of the game.
you can't say it's not going to work. You don't know what's going to happen 10 years from now. Maybe someone buys the gym, maybe someone buys that doctor's office in another house. And I don't know, down
That's
the bay or
financially
something.
irresponsible.
I think it's irresponsible to put it on change our bylaw before you know if the state has all these concerns already. I just think you're, I hate to say it, but the character of the town, it just blows my mind that you would even consider any of these areas.
Thank you. Any,
Well, the only response I have to offer is that if we don't pass a bylaw with some restriction, then there is no restriction. And they can go anywhere in the town. So it's a devil's choice.
Well, I mean, our building inspector said no.
I know, and we went to court and all that, so.
Right.
Jackson Esket Jr., 1351 Tremont Street, also a member of the Finance Committee. And the Finance Committee has the honor or whatever to move and vote on every warrant or article. And although this has no financial significance to the town, we had some questions that we wanted to clear up before we voted it. We wanted to vote correctly. So we need a little information. The best, are we only talking about picking off low-cost electricity, or are we talking about solar panels charging a battery storage area?
the principle the state's operating on is that because the renewable energy is variable, the batteries are a necessary component of renewable energy. But the statute and the bylaw doesn't mention solar at all. It is strictly batteries.
And it
And nothing else. There's no permit, there's no additional requirement for solar or permission for solar.
limit anyone from using solar and charging a battery pack over 1,000 kilowatt hour. I mean,
Installation.
100.
If it's over 100K, it would fall into this.
Yeah, I mean, I think that's a good question. I'm not entirely sure, but I believe that even if a developer is putting in a battery energy storage system, even if it's, integral to a larger solar project that the developer is also putting in, I believe they have to go through all this because, even if that battery storage is like right in the center of a big solar project, and its only purpose is to take the energy from the solar and store it and actually put it back to the grid, I think it would still count. We have town council here, so it could be a question for her, but I believe, as Jack said, solar is not mentioned anywhere in this little bylaw, so it's hard to know for sure, but I would think this bylaw would still regulate that, that proposal. And I think nowadays, of course, a lot of probably most of the major solar arrays that are proposed nowadays probably do have a battery energy storage system, adjacent to them or kind of within them, associated with the, like on the same property, like associated with the project. So it's an important point.
But the threshold is still 100 kilowatt hours.
I think so, yeah. And obviously, like any major solar project, obviously it's one thing if people just have a few solar panels in their backyard on the roof, but any developer who's proposing a major solar project as kind of a freestanding thing as a business proposition, if they're putting in a battery there as well, I guess it'd probably be substantially over 100 kilowatt hours. Yeah.
Well, I guess maybe I'm going to try and reach into your question a little bit here. If one is contemplating a large solar installation with a high capacity and requires a high capacity battery array, this regulation is all about battery energy storage systems and specifically dedicated use buildings. And if you were proposing a battery energy storage system that was over 100 kilowatts but was installed within another structure that already existed,
yeah,
I don't know, would this disallow that?
I believe this would still regulate that.
It would regulate it, but it wouldn't be a dedicated use building, so it wouldn't apply. That's kind of.
It might just say that it's not allowable for us. There is the provision here, I think, where it can't be.
Well, we have the 10% administrative use within the envelope.
Yeah.
That presumes a dedicated use building. And so the bylaw implies that any structure must be 90% filled with batteries.
Exactly, yeah. So I think what this says is that if you're just trying to put in a huge, more than 100 kilowatt hours battery system in your building, and it's just like a small part of the building, then it's not allowable, I believe.
So, Chad, I think 62.5B, there's non-dedicated use buildings.
There it is. You can't have non-dedicated use buildings. Again, this is in the context of site plan review, right? So that's just saying on your best facility that consumes an entire parcel, you can't have anything but best building.
Yeah,
It doesn't say you can't put a best in a building that's already there.
I think it does. I could be wrong, but I think that's how I would interpret it. Yeah.
Mm-hmm.
I think in most cases, I don't know. I think in most cases, if people are putting it in within the existing building, it's probably just for the purpose of as a backup system. So it's probably going to be 100 kilowatt hours. And if somebody's building a serious best system that they want to run on a commercial business to sell it, just to sell energy back to the grid, to store it and sell it, it's probably going to be an entirely separate thing. It could be within a building, or it's more likely going to be just kind of freestanding, but it's probably going to be sort of its own separate development, I think, typically from the research I've done. And it seems like in most cases, from what I've seen, they're not actually within buildings usually. These batteries are, the kind of size that they're maybe like 20 feet long, 10 feet high, 10 feet wide, and they could be like 10 or 20 or 30 or 40 of them just kind of arrayed all on the property, but they're not really within a larger building. They're just kind of freestanding, kind of sitting there on the ground, surrounded by some other electrical utility stuff. So.
If you look at some of these roofs that we have in town, they're quite expansive, and you can generate an awful lot of electricity, you know, and still be within the zoning law. Okay, couple of quick questions. And mine is numbered differently because I'm working off the warrant. I don't have the actual thing. But battery or batteries in the definitions, the last sentence says, for the purpose of this bylaw, batteries utilized in consumer products are excluded from these requirements. And these consumer products isn't the best consumer product? No. Okay. This is kind of a personal question, but waterfront scenic area overlay district. Why was that part of the restriction?
Probably for the reason that was raised, because we wanted to make sure that our,
Yeah,
so that our natural resources were not impacted.
It's in your boathouse,
Okay.
right?
They give us
Your storage, your best storage area could be in your boathouse. And that could be your unit. I don't know why anybody want to waste a boathouse on that.
I think we were just thinking along the lines of protecting if there were any hazards, we would protect our natural resources from those hazards in the event of the intention.
So often these projects are not the most sort of beautiful things necessarily. And of course, beauty is not in the order, but for the most part, these projects would not be regarded as the most beautiful things. So we probably don't want them in places regarded as more scenic areas.
In the eyes of the beholder. We asked that you label the properties on that sheet with the green. Did that happen?
Oh, to label the property?
Yeah.
Like the actual,
Yeah.
go deeper, so
Right.
you can actually see like how many houses there are?
So we did create a new map. I mean, I thought when I was at the FinCom meeting, I thought, because you were sort of said they would like to see a map of like the basic kind of protected properties, like town-owned properties, wildlife trusts, and so forth. So we did create a map actually of that, and kind of overlapping it with the areas where best would be allowed. And basically, there's not really much correlation. Like there's, you know, like maybe about a third or so of it was overlapping, but there's not much over. Like, you know, it's not really more likely or less likely that one of those protected areas is going to be within the best allowable area, if that makes sense.
But that's why we wanted them labeled, because certainly Wildlands Trust property isn't going to have a best on it.
Or a town-owned property, probably.
And town, so that's why we're looking at that saying, so how much property are we really talking about? By the time you take the town out of it, and Wildlands Trust, it's not a lot left.
Yeah, I've got one copy of that map, and I should give credit heavily for creating that.
If you can
contribute to that. Yeah, I mean, we can probably email it to you, or otherwise bring our copy.
I can take it and get it down, we print today, get back tomorrow, whatever. But
May I, can you pass it down?
Oh, yeah, sure, yeah. So I think basically the yellow areas are the various protected properties, or properties we regard as protected, you know, Wildlands Trust, maybe under conservation easement, town-owned, state-owned, a few other categories, but not chapter 61.
The ones that are green are the town owners?
No, yellow. And then the green, The green are the areas where best would be allowed. So it kind of gives you a sense of how much overlap there is. And I'd say for the most part, it's pretty random, like it's not more or less likely that there'd be those protected areas within best areas, if that makes sense. So maybe about, I mean, you can eyeball it yourself, but maybe about a third maybe of the best area would, you know, is those townhomes areas. Or I'm sorry, those protected areas.
Just partial.
I was planning to bring that to the FinCom meeting on Thursday.
Would it be possible to have this at town meeting for people to see?
Yeah, I get 3 copies.
Yeah, I think that's good information.
Would you be able to have this at town meeting so people can see this?
Yeah.
Because it's gonna come up.
Yeah. You know, I think from a zoning point of view, I don't think it's like a major issue. I mean, if we were kind of manipulating the process and if we were manipulating the choices that were allowed in such a way that was kind of like blatantly invading you know, preventing it from being allowed anywhere, then I think it would be an issue. But otherwise, I don't think the Attorney General is going to ask us like, oh my God, you know, it looks like, you know, because the reality is, anytime you allow things in the zoning bylaw, because of, you know, the setback rules and all kinds of rules, there are always going to be a lot of properties that can't be done for one reason or another. You know, in some cases, just because the property is worked for as a commercial space, perhaps for all kinds of reasons.
Did you want to take this, JR?
So I can try and grab it.
Yeah, I mean, if we can easily.
You've got a copy.
I've got a color printer, so
Yeah.
we can easily make those nice 17s for what I don't try
The rest
to
of
do.
So if I could have 9 copies?
One thing, when you don't go online, then it'd be a best to that. People that. JR, do you have any other questions? JR, do you have any other questions?
No, I'm good. Thanks very much.
Okay, thank you for coming, appreciate that. Do you still need me or Matthew to come on Thursday?
I'm gonna try and get it so you don't have to come.
All right.
Thank you.
For everybody in the audience, we have town council here at the back. Counselor, is there anything you'd like to add, or any input, or anything you might maybe before we chat?
Sure. So, Amy Questle, Town Council. So there are a few cautionary sections that I wanted to bring up. The first being the noise section that most likely will be found to be unreasonable by the Attorney General. What you guys are discussing and now is a public record. If it's a town meeting, it's going to be sent to the Attorney General, so that is not helpful. So that will reduce your percentage. And so what we have to remember is that unlike religious and educational facilities that you cannot regulate, solar, you can regulate them, you cannot unreasonably regulate them. So the Attorney General will be looking at what is unreasonable. Some of the things that I would flag for you are the setbacks, the 200-foot setback to a residential dwelling, the noise, and putting your zoning districts over properties that are, protected properties, Article 97 properties. So those are some of the things that are just I wanted to flag for you that could be determined to be held unreasonable by the Attorney General. They are looking at these bylaws with a microscope, and they are definitely looking at them from the lens of what is unreasonable. So that's the way it is. We would hope that we would hope that only, that the Attorney General, if she found that there were sections that were unreasonable, only those sections would be deleted. So, for example, the noise, that is its own, that's its own section. So if she found that that was going to make the bylaw unreasonable, we would argue that she could simply just delete that section. When it comes to the setbacks, if she deletes the setbacks, that means there's no setbacks. So it is a concern.
Amy, quick question. As we stand here today, we have no protections. Theoretically, somebody could come in and place one of these at any place they want to.
That is what the trial court has determined.
Right, and it's covered by appeal.
No.
It's not?
No, because New Leaf has abandoned their project.
That's right. But theoretically, the trial court or the land court has determined that under the law, under the statute as we stand it today, it can be cited anywhere. If this bylaw was to be passed at town meeting and gave us some protections, and subsequently the noise provision or the setbacks are then disallowed by the Attorney General, where do we stand during that period of time for town meeting when it was approved until the Attorney General rules on the noise? Is the noise provision applicable that's been passed at town meeting until the Attorney General says otherwise?
Yes. So as all zoning, there's a wrinkle. So 40A Section 5 specifically states that a zoning bylaw is effective upon the vote of town meeting. So essentially, if you vote on it at 8 o'clock at town meeting, at 8:01, it is effective. However, Chapter 40, Section 32 provides that the Attorney General has 90 days to review and approve any zoning bylaw.
Sure.
So we kind of have a gray area. Our position is that the zoning bylaw is in effect, and if a applicant comes in during that time, they decide to, act on a new zoning amendment, they do so at their own risk. So if they, if they do come in to try, to build something and the Attorney General strikes it down, they would have to remove it because it would be at their own risk.
I guess I just want to kind of follow up on what Matt said, just to clarify, because I think it's going to be a thing at town meeting. I mean, it's kind of already said that, some people may say, why are we proposing this zoning bylaw to allow best projects in 10% of our town, because at the moment those zoning bylaws don't allow best projects in the town. So, it sounds like you're saying basically, because of this litigation and so forth, the courts have found, at least for the moment, that best projects can be built, anywhere in the town, because of, it's not the Durham, because of the similar to the Durham and so forth. And so the whole point of doing this is to change our situation from currently where, because we're not regulating it, in effect, they can be built almost anywhere in the town, to a situation where we're restricting it to approximately 10%. I just kind of wanted to show that logic that my logic is correct, I guess, so to speak. I mean, the proposal for the project on West Street, or East Street or West Street, like by New Leaf, was like a residential area and so forth. So, leaving aside some environmental factors, it seems like at the moment they're allowed. We kind of have to allow them in almost most parts of the town at the moment by that court's decision.
Correct. Mr. Ray is correct. Because of the land court decision, they have to be allowed everywhere unless you have a bylaw. Now, there is no court decision on what percentage of your town should be zoned. I don't know if 10% is enough. We have nothing on that.
Can I ask a question about the frame? Because we keep hearing the term reasonable, and that sounds very subjective to me and entirely dependent on context. What is reasonable in an industrial area, not a reasonable residential area. So how do we define that? Unless it seems so arbitrary as to be meaningless.
So if in your town you had 35% of your town was zoned industrial, and you decide to say that BESSs can be allowed as of right in industrial zones. I think you would be fine. In Duxbury, we have a problem. We have a hurdle, which is that, as the chair stated earlier, you don't have any industrial districts and you have very, very little commercial areas. And so, where to put these and where to allow these, that's a policy decision that this board has to make, unfortunately. That's on the planning board, and where to locate these things. Whether it's reasonable or not, again, I don't know. We argued to the land court that having this BESS in a residential neighborhood right next to, a residential occupied house was not appropriate. It was reasonable to say you can't have it there. And we were not, the Judge Resnick did not agree with us.
Was there a rationale or just?
The rationale is that, the rationale was that if it's allowed and that it is a protected use under 48, Section 3, Paragraph 9. We also argued that, battery energy storage systems are not necessarily solar, particularly the West Street project, where they were going to be storing less than 50% of their storage was going to be from solar. So they would be storing, they were storing off the grid. Who knows where the origin of the power came from. So, unfortunately, that didn't save the day either.
Thanks for the
And are you aware of any legislation that might be coming down the pike, so to speak?
So there are many, many bills, and there are some, obviously there's the new green energy legislation that came out that promotes solar, promotes battery energy storage, provides for a expedited permitting, and then there are bills to dial all of this back. And this is the same as MBTA zoning, which we all went through together, where there was bills to stop MBTA zoning. It is still effective. So I'm not privy to the ins and outs of how the legislature works, but it doesn't seem to be working very fast.
That's helpful.
And to clarify, oh, sorry, go ahead, Steve. To clarify, if this zoning amendment was passed at town meeting, and subsequently the state legislature passed more restrictive statute, that would overtake or supersede, thank you for the word I was looking for, supersede, take precedent over our zoning bylaw.
Presumably, depending on how, yes, depending on how it was set to regulate. Usually, you go, statute, state regulation, bylaws, regulations. So yes, most likely. And if it didn't, we could always go back to town meeting.
So, just to kind of go back to what Dad was talking about, the term reasonable, and you gave a very good explanation of what reasonable would mean. But just to be clear, when we talk about in a situation where the bylaw that we would enact would be challenged on reasonability grounds, the prerogative, I guess, of determining reasonability would at first lie with the Attorney General. So it's up to the Attorney General to determine what is or what is not reasonable. And then if litigation were to follow, then it would be the court's decision as to whether something is reasonable.
Correct.
Okay.
Correct. So the Attorney General standards or review criteria is that the bylaw cannot be repugnant to state law. And so with BESSs, they have taken that to place it upon themselves to determine what is reasonable or not. If it's outwardly unreasonable, they will strike it. But generally, it has to be in direct contradiction to state law. And their position is that 48 Section 3, Paragraph 9 allows for solar to be, allowed, not unreasonably. So it's not. There's no outline, unfortunately.
Have any other towns tried to put a noise ordinance restriction on?
I looked. I didn't see any like this. This stems from a condition that the town of Norton put on a solar project that had it had its own energy storage, it had its own battery system, inverters and batteries, and it was surrounded by residential homes. It was actually a dual-use solar array, so it was over cranberry bogs, and then they had battery energy storage next to it, and it's the next sun case. It's actually been in land court now since I think 2018, and it's still going. But it was remanded back to the planning board twice, and the second time, the solar developer agreed to the condition with regard to the guys. So here, it's going to be mandatory.
Maybe I guess a quick question. This has been kind of late to be asked this, but is it appropriate for this to allow the BESS systems by special permit as opposed to by right?
Oh, yeah, it's fine to have it by special permit.
I know special permit gives a lot more discretion to deny a project or. And then got my other question, but I guess one question is, as far as what we were discussing before, like if the BESS is within a larger solar array and it's kind of part of that whole larger solar project, does this bylaw still apply to a BESS of that nature?
Well, there's the 100 kilowatt hours, and then so one of the things that you have to look at is if your solar bylaw in your zoning bylaw, if any of the areas overlap, and I'm not sure if they do.
Yeah.
So you would most likely not have a solar, you wouldn't have a solar array in a planned development district, for example. So you wouldn't run into that problem.
Okay, now I remember my other question is, for the setbacks. So you're saying 200 feet seems questionable to you. I mean, do you recommend?
No, I'm just flagging it. Is what I'm doing. I'm flagging it. I don't want you to get the Attorney General's review and say town council never told me any of this. I don't know if it's reasonable or not.
I guess so much as a sort of uncharted territory. I guess the laws sort of evolving before.
Well, we can certainly anticipate that, and we touched on this at the last discussion of this, is that it's a matter of crunching the numbers. And unfortunately, what we find ourselves doing in this exercise, as I said it last time, this is a menu. A lot of these parcels aren't on the menu because they don't work. Who's going to do that math? Are we going to do that math so we know what the number is, or are we going to turn it over to the AG, grind through the GIS and say, oh, 20% of these right off the bat you can't use, and that's only 7%, and that's not good enough. I mean,
Cool. Don't you have a color-coded map right there?
yeah, but it's a matter of looking at setbacks, adjacent properties, looking at every single parcel, and that's what, frankly, a prospector would be responsible for doing for their own business. So this is my complaint. I'm sorry, complaining here. I don't have an answer. We're doing the homework to enable this. That really rubs me the wrong way. You know, I mean, it should be at least, you know, an equal effort. If there has to be this, then it ought to be planned and not just thrown at us. You know?
I would say that you know, an overlay would probably be the best way to do something like this. But again, in Duxbury, that I don't know if you'd end up in a better position because you don't have commercial, you don't have industrial. So, you know, unfortunately, that's the position that you're in. And your so-called business districts just aren't big enough. Any other questions?
Madam Chair, I think the number of that policy right now.
Yeah.
Yes, actually, when I ask you a question.
Come on.
You have to the microphone again?
You, oh,
Thank you. That's so that our audience can
here. Okay. So McEntee, Rose Report. I guess my question was, and I know that you were saying flagged the sound, but isn't that why Matthew, did the, quoted for the sound, the 10 dBA above the ambient noise because it matched the states. So we were trying not to be flagged by the state. And so it's the ambient standard 310 CMR 7.1. A source of sound violates Department of Air Quality regulations if it increases the broadband sound level by more than 10 dBA above ambient level or produces a pure tone condition. And then farther down, this is right by the state, it says residential limits in some areas, sound levels are generally capped at 55 dBA during the day and 45 dBA at night. So that's the state. So I appreciate what you're saying, and I thought that's why you guys were trying to match it, so it wouldn't stand out. Does that stand out, do you think?
So it's, if I may, it's not so much the 10 over ambient, it's the process to get there, the amount of steps that the developer has to take. That is more of my flag.
Thank you. All right, any thoughts from the board? Questions? Jen, any questions or thoughts?
No, it's a complicated process.
Agreed. If there's nothing else, no other business, is there any other business? Very not all.
We're gonna close it here. Close it here.
Oh, yeah, we have to close it here. I'm with that.
Actually, I guess, I'm sorry. It might be a question for town council. I mean, it sounds like we're going to be discussing this best zoning bylaw at least kind of sporadically, occasionally at our future board meetings up until annual town meeting. So would it be wiser to continue this hearing to allow that, or just to close it? I think if we close it, I believe we're still allowed to have those discussions, but maybe town council could. Right.
I'm surprised actually that we didn't get more public engagement.
Yeah, it's so hard to predict. Sometimes it just depends so much on social media. Like, I thought we could easily get 20, 30, 40, 50 people tonight, but at the same time, I'm not shocked that we only got a few. It may build up on social media as we get really close to town.
Yeah, I agree.
If you close the public hearing, you cannot discuss it.
Okay. Going forward, and even discuss the bylaw amongst our.
Answer resident questions, nothing?
Not a public meeting. I mean, this is a public hearing.
Yeah.
So,
But yet we've talked about the bylaw before, so.
I mean, are you going to put it on, is it going to be on your agenda every single week?
Yes. Okay. Yeah. So if we close it, we'd be able to talk about it if it's on the agenda? Or you saying we have to?
Post.
So you say we should continue the public hearing if we plan to discuss it within the board.
So you have to make a recommendation to town meeting. So before you close the public hearing, you have to make a recommendation that the planning board is in favor of the zoning bylaw or not. You're either recommending it to town meeting or not, or you let 21 days go by and then you don't have to. So if you close it now, you have the time for 21 days to go by. If you keep it open. It's really up to you guys.
Yeah, I think more the key question is just, since we feel pretty certain that there'll be the board is going to have some discussions about this at, the future board meeting, even if it may only be kind of occasional or, not necessarily, you may not go like a full 30 minutes to talk about it, but there'll probably some discussion. If that's the case, it sounds like it would probably be wise to continue the hearing. And then as Amy said, when the time does come to close the hearing, it would be standard, regardless of the 21 day, it would become a standard practice for the board to officially decide and vote on whether they actually support passage of the bylaw or not. And then we'd probably just write a letter, the official letter to the select board stating that.
I don't know your schedule, but it appears to me that there maybe only be 2 meetings. Your town meeting is March 14th.
Yeah.
You do have the earliest town meeting that we know of. March 14th is early. Yeah, you just have to make a recommendation for time.
When does the town need us to decide? Probably by the 23rd, I would think.
I mean, I think in theory, I mean, this is not a good idea, but like in theory, you could do it like the day before, the day of. But in practice, I think would be sort of reasonable or wise, professional, at least maybe a week or two before.
Well, I think it's better to have our decision printed within.
It should be printed in warrant.
Yeah, so it would be better because I know sometimes when the boards can't meet and they don't, it's kind of confusing when you go to.
Yeah. It would be sort of unprofessional to do it like the day before.
Well, is there any possibility that we will want to change any of this? I mean, we've already passed closing the warrant, and anything else that has to be done, as you pointed out earlier, either through the motion or more complex through amendment. And I'm not sensing that we really think this can be improved or should be altered at this point.
I think the last meeting we talked about the fact we didn't want to change anything on the floor, and that's where we are at this point.
So I think if it's settled, if this is a legislation that's in the can, there's really not any reason to continue the hearing.
It's up to the board. I mean, I guess I'd be inclined to suggest continuing the hearing because it seems like there's not much harm to it, but it's still up to the board. You could, in the next 2 weeks, you suddenly could realize, there's something here we really do want to discuss about this. So then having the hearing continue will give you that benefit. As far as it being finalized, I mean, I think that's basically true. The warrant is closed. My sense is that if there was something of incredible urgency or importance, they could, reopen. I don't know if reopen is the right phrase, but they could revise the warrant and reprint it. But in practice, they'd probably be resistant to that. Yeah, I think for practical purposes, this is probably finalized. And as you say, we definitely don't want to be proposing amendments on the floor of town meeting. Of course, we can't prevent other people from doing that if they so choose.
I'm okay with it.
Yeah, and I guess the other, in my mind, the idea behind keeping the hearing open would be to be responsive to public input, of which we don't need the hearing to remain open in order to be so responsive. So I guess with that in mind, I'd be inclined to put the close here.
Motion?
It sounds like from what town council said, it sounds like town council advised that if you are going to close the hearing, you should either kind of, before you buzz it, do a vote on whether or not you're supporting passages at town meeting. Although in theory, you can just say, okay, there's more than 21 days, so we don't have to. But I think it would kind of be more professional to do so. So probably we should do.
I think it's behind the vote. I mean, we've had a lot of good questions.
Yeah.
We had our public hearing. We're comfortable moving forward.
Yeah, I don't see the harm in continuing it, but in the event that, if we continued it for the next, in the meeting in 2 weeks and nobody shows up in the public, then we make a motion to vote and close it, or we can close it today and vote. But that cuts off, to Steve's point, that cuts off any possibility of the public coming in the next 2 weeks until the next meeting. Either way, I don't think there's going to be any changes to the language of the warrant. So whether we want to continue the public hearing, if we think there'll be any townsfolk that will come to the next meeting to discuss. If we don't, then we close it today. Or we can be one of the first agenda items at the next meeting.
If I may,
Yep, please, Jen.
next meeting, probably, yeah, been closing it.
We're getting only every other word. Not sure why.
Is this any better?
Maybe.
Keep talking.
Sorry. I would propose that we keep it open until the 23rd.
Okay, Jen, we heard you say you would propose we keep it open.
Correct.
Okay. Okay, I'm fine. I'm fine with that.
Okay. We'll continue the public hearing.
Second,
Second.
that was your proposal, that was your motion. Do we have a second?
Second.
Okay. Any discussion about continuing to the 23rd? Hearing none, we'll call for a roll call vote, starting with Jen.
Jen Turcott, aye.
Matthew Ray, aye. Eric Carpenter, aye.
Kristen Rapp, aye.
Oh, I'm sorry, I.
You can't know.
All right. Okay, John.
Thanks, Jeff.
All right, anything else that the board wants to discuss? Anything else under we have public, the planning board administrators?
Oh, we got-
No, I just mentioned a few things in the report, maybe talk about this, about that. Did you? Okay.
Thank
Anyway, I
you.
mentioned, you know, in the report that you can read for yourself. It's just kind of FYI type stuff. It's about it.
Very helpful, thank you.
Long, yeah, really, really appreciate it.
Yep, isn't it nice that, after every TA, community bylaw, will have to work.
Yeah.
Any further action?
Mhm.
Attorney General? Anything else? Anybody? I'll entertain a motion to close, and then close the meeting.
Sure.
Adjourn.
Second.
All right, any discussion, all those in favor to close the meeting, Jen?
Jen Turcott, aye.
Matthew Ray, aye. Eric Carpenter, aye.
Kristen Rapp, aye.
Oh, I'm sorry, I.
You can't know.
Motion carried. Thanks, Rhino.
Thank you.
Good night.